Welcome to Amici, News and Insights from New York Courts. I'm John Carr. Today we have a very special and unusual program in two ways. One, we have both audio and video for this podcast. And two, we have a very special guest, a return guest, and a very historic guest. And that is the Honorable Betty Weinberg Ellerin, the retired presiding justice of the Appellate Division, First Department. Judge Ellerin is back with us to discuss a fascinating new report on gender fairness in the courts, a topic that she knows a little bit about. Justice Ellerin was the first woman deputy chief administrative judge for the New York City courts and the first woman appointed to the Appellate Division's First Department. She is now senior counsel to the Manhattan law firm of Alston and Bird. Justice Ellerin also chairs the New York State Judicial Committee on Women in the Courts, and that is the focus of our discussion today. But before we do that, if I may, I'd like to bring some context to this discussion. Judge Ellerin, all of us in the courts are pretty familiar with who you are and your career and your accomplishments and your contributions. But I'd like to peek behind the curtain a little bit, if we could, and ask you, where are you from? What's your story? Tell me about your childhood and how does all that relate to where you are today?
Okay. I was born in the Bronx of immigrant parents, both of whom came from different parts of Europe. And we moved to Connecticut. It was the middle of the Depression, and my father got a job in Connecticut at a place called Derby. That's the Naugatuck Valley, about 10, 12 miles from New Haven. And that was where I grew up until my first year of high school. I went to grammar school there, my first year of high school. And that was a very nice place to grow up in that regard, except I'm Jewish and it was a very anti-Semitic area. And that had a great impact upon me. It colored my attitude about how I felt about other minorities. Because I was in that context, a minority, and I felt the prejudice, the nasty comments, what have you. But in any event, we moved to New York when I was going into my second year of high school, which was the right time because all the other kids were going into high school from junior high. And I went to a school called James Monroe in the Bronx. We returned to the Bronx. And that was a school of, well over 600 students. And I graduated as valedictorian, which was, very nice and should have really given me an open ticket to many schools. My family didn't have much money, unfortunately, but also I graduated in 1946. That was the year that World War II ended. And so all the veterans were returning. But I wanted to go out of town to school. That was a dream of mine. And when we were in Connecticut, my parents had friends who had children who went to schools like Ohio, Indiana, etc. And I had no guidance, but I sent letters to those schools. And I got a scholarship to Indiana University. So I went out there. Gorgeous, gorgeous campus. That was the first week. I loved it. Second week, I found out it was Klan territory. Well, that didn't sit too well with me. And I was constantly marching. And after a year, I got out of town, out of my system, came back to New York, got a partial scholarship at NYU, which was a school I was happy to attend for a couple of reasons. One, I was delighted to be in the city atmosphere with the excitement, the political dynamism, and what have you. And it was a place where I could get 2 degrees in 6 years. The first year at Indiana counting, and I took extra courses, and I did. I got a BA and an LLB. And for me, the extra year's tuition was important because I had worked my way through school, worked in the summers, I worked at various jobs during the year. Then I graduated from law school. And NYU did not have a particularly great placement service. I must say this about NYU. For the most part, it was a friendlier atmosphere for women students than many of the other law schools. NYU was ahead of the curve in that regard. And I never felt out of place there. If I had a couple of incidents with some of the young men, I had a lot of moxie. I remember early on, one of the guys came over and said, "What are you here for, to get a husband?" Now, I expected that question. So I said, "Well, to tell you the truth, yeah, that was why I came. But when I saw what was available, thought I'd get the degree instead." Well, I'll tell you, nobody ever bothered me again. And I had a group, a study group of all young men. We remained friends for many, many years. So law school was, I viewed it as something I had to do in order to become a lawyer, something I had wanted from the time I was about 12 years old, because I wanted to be a labor lawyer. I was going to help people. In any event, when I got out of law school and went looking for a job, the fact that I was a woman suddenly became very evident. I went on a lot of job interviews, things that I don't think I know wouldn't happen today. I go into an office. "Well, we can't hire you. The clients wouldn't like it." Or those who didn't use that line, "You'll get married and have children." And I used to say to myself, I wish you'd tell that to my mother, who was very concerned when I went to school that might not happen, although it didn't. I had 3 wonderful children. And in any event, I ultimately got a job because I was a woman with a maritime firm. The person who interviewed me was a pretty young guy, and he thought it would be very helpful to have a woman in the firm. And when he went in to tell the senior partner that there was somebody he wanted him to interview, I heard the scream, "A woman? Are you crazy?" In any event, 2 years thereafter, when I told that partner I was leaving, "No, you can't leave. I'm building a department around you." And I was helpful. I was able to do things in the firm, or in terms of investigating things, in terms of dealing with the seamen, that were very helpful. The seamen treated me like a lady. And so I could, tell them, "Well, look, this is, when we get a settlement, this is your share, this is the firm share." They were like lambs. When one of the partners or one of the other men would do it, you'd hear screams. So I was helpful, and it was a wonderful body of law because I was in the federal courts a lot. Now, in the federal courts, I would, and this was true in most courts, when you'd come in as a young woman in those days, and I don't think it's any secret about how old I am. I'm 91, so you can imagine how many years ago that was. The first question the nice judges would ask was, "Are you a lawyer?" And I say, "Yes, Your Honor, I am," and that would be it. The not so nice ones would start out with, "We don't allow secretaries to answer the calendar," or whatever it is. And then I'd have to explain that I was a lawyer. Now, that really was not very nice, but it was something that we accepted, the few of us who were in the profession at that time. As time went on, I had the opportunity to become a law clerk to a judge in a court that no longer exists. It was called the City Court of the City of New York. Now, this judge was, his name was Harry Frank, was a sort of avant-garde guy. He liked the idea of being different. And the fact that I was a woman was something that he liked, because he would be, most of the other judges, actually all of them, had men law clerks. So when he interviewed me, he looked at my resume. "Oh, do you want me to swear you in now, or do you want to wait for your parents and husband. I said, no, I have to give my firm, notice. So he said, tell you what, because there were some political overtones to it. I'll swear you in now, and I'll give you 2 weeks to clear it up with the office. And that began my career in the court system. That was a court that had jurisdiction up to $6,000 in civil cases, but it also had unlimited jurisdiction in maritime cases. So that was a natural fit. And I remember the very first case that I had in that court, he was hearing a maritime case. And he said to me, come upstairs and I want you to sit in the courtroom. And I'm upstairs and a witness is on the stand, a first mate. And he's talking about, and the rope, and he's making these motions. And nobody can get the word out of him. So I raised my hand. I said, Judge, I think he's talking about kinks in the rope. Well, the place broke up because of all of these, guys who were maritime lawyers. Look who knew what the guy was talking about. And I wrote some, under his name, some very interesting decisions, some in the maritime field and some in other areas. And I'm going to be very honest. Being a woman was helpful. They expected so little from a woman lawyer that if a woman was competent, if a woman was good, she was brilliant, she was exceptional. And that used to be the word, oh, Harry Frank's got this exceptional, law clerk. And by the way, we were called law secretaries in those days, notwithstanding that I was the only woman, but law secretaries. And as years went by and we were in the Supreme Court, I remember I would get calls from lawyers. I would like to speak to the judge's law secretary. And I'd say, this is the judge's law secretary. No, the law secretary. I said, no, counsel, this is judge's law. No, I mean the man. I say, counsel, women have been admitted to the bar of the state of New York since 1869. This is the judge's law secretary. Can I help you? But that was the kind of thing, I didn't have much problem with the lawyers, though. They were smart enough to know that the judge's law secretary or law clerk, if you wish, pretty important person in chambers, and they all acted, for the most part, with great respect.
That's good to hear. Now, let me take a step back for a moment.
Sure.
I'd like to go back kind of a long way. You were a young woman. You may have even been an attorney by that point when Brown v. Board of Education was decided. But your activism, your caring about these sort of issues, your experiences as a child experiencing anti-Semitism, I'd like to explore that. What were your thoughts at the time? What was going through your head? Were you aware of all this?
Let me put it to this way. I started marching when I was 16 years old. I was very active in high school clubs. When I got to college, I became president of the NYU Democratic Club. I was always marching against injustice, including racial injustice. At Indiana, that was what soured me on Indiana. There was a conference on racial equality, and every restaurant in town put up a sign, "We cater to white trade." Well, it was good for my diet, but I never stepped into another restaurant in that town, and that was what decided me. No way am I staying here. They can keep the rolling, beautiful hills and beautiful buildings. This is not for me. And I was marching there as well for, I think the African American, although they were called at that time, the Black fraternity sororities were not, and I was not a sorority person, but they were not eligible to be part of the group, and I marched against that. Whenever there was an issue like that, I was marching. Actually, once at NYU, I was marching, and I'm handing out a leaflet, and my professor, Lois McDonald, a labor law professor, she was wonderful. passes by, and I don't see who I'm getting, and I hand out the leaflet, and she looks at me and said, "Oh, Miss Weinberg, good to know where you are, because I missed you in class today." But, I was an activist even then.
Did that come back to bite you in any way? Did that?
No, no, not that I have always been very outspoken about those kinds of issues.
And that outspokenness really comes from your own experiences, right?
Yes, and because I think it's the right thing to do. I wanted to be a labor lawyer because my father, had been a union person when he was younger, and I wanted to help working people achieve, proper status. Trouble is, the lawyers who represented unions were not waiting with open arms for me, and it was a different sort of atmosphere by the time I graduated from law school. I had an idealized version, of what union law would be like.
Sure. Now, in 1986, the New York State Task Force on Women in the Courts issued a report concluding that gender bias was a pervasive problem in the courts, and that
That's
women
right.
were frequently denied equal justice, equal treatment, and equal opportunity. Now, your committee revisited that issue,
Right.
I don't know, 34 years later, and issued a report. And was it late November, I think?
Correct.
Showing that there has been progress, but we have not yet reached the promised land of equality in the courts.
Correct.
Is that accurate?
First, let me tell you how the first report came into being. At that time, I was a city administrative judge and had great rapport with then Chief Judge Lawrence Cook. He came from Monticello, but he was truly a man committed to justice. And there were writings at that time about the fact that women were not being treated properly within our court system. And New Jersey had done a report, and a group of activist women, contacted me, and I said, "Yeah, we're going to go and talk to the chief judge." And we did, and we spoke to him and told him we thought we needed that kind of a task force too, to explore whether there was bias, notwithstanding that we knew that in fact there was, but you needed to support that with data. So he was a little taken aback because he was such a fair person himself. He thought that, was sort of a criticism of him. But after I spoke to him, I got a call the next day. "Judge, I listened to what you said, and we're going to have that task force." And he was wonderful. He appointed a task force that included people from the big firms, legislators, educators, what have you. Actually, very few of what you would call people committed to gender equality. I was a little disappointed, but he was much smarter than I, because those people, when they are converts, believe me, they go all the way, and they have an impact far beyond what those who are known to be, sort of prejudiced in an area can have. And they came out after hearings, after meetings, what have you, with a report that, as you say, said that gender bias infected all areas of our court system. And one of the recommendations was the appointment of a permanent committee to follow the progress. That report had a lot of recommendations. By the way, I was not a member of that task force. Had a lot of recommendations as to how to address the incidents of bias that pervaded the court system. And it said there should be a committee to oversee the implementation of those recommendations. Now, the chief judge to whom the report was given, because there had been a change, Judge Cook had to retire, was Saul Wachtler. And he took it very seriously. His Law Day program, right after the report was presented to him, was on that issue, that he was committed to seeing that those recommendations were fulfilled, and he did establish the committee. I think it was called the Committee to Implement the Recommendations of the Task Force on Women in the Courts. That was quite a mouthful. Ultimately, I think it was Judge Kay who changed it to the New York State Committee on Women in the Courts. And the first chair of that committee was the Honorable Catherine McDonald, the administrative judge of the Family Court. As I said in the report, in the current report, that was an inspired choice. She was fabulous. And she came up with the idea that, no one statewide committee can really have eyes and ears everywhere, and that you really need input from the localities. What's going on in the various districts? And so she was the one who initiated the local committees. We have a local gender fairness committee in every one of the judicial districts within the state. And in a sense, they are the eyes and ears. And we have an annual conference that in a sense compiles all of what we hear from around the state. And we try to incorporate it in what our focus is for the following years. Now, at one of those annual meetings, about 3 years ago, I think, when it was about 30 years after the original report, I don't know, we had a whole big discussion at the annual meeting. These are problems that still exist, etc. So mindful of how we approached it, how it was approached originally, we realized just talking about it in that abstract way did not have the same impact as if you have concrete data to back up the problems that you are complaining about. So we decided, I guess it's time maybe for another task force or for another report. And as usual in the court system, money was very scarce, but this is one time, I'm not a big technology lover, as everybody who knows me knows, but I appreciate that in this instance, technology was very helpful. While we couldn't have the meetings and the impressive investigatory efforts that the original task force engaged in, we could send out a questionnaire to every lawyer in the state of New York, because don't forget, we're the Committee on Gender Fairness in the Court System. And so what we did prepared a questionnaire that in many ways was similar to the original one. And a copy of that, originally we had the questionnaire was done through bar associations, and that was sort of, catch as catch can. It was a combination of all sorts of information gathering. But here we sent out the report to every lawyer in the state of New York who gave an email address. And we got back, well over 5,000, close to 6,000 responses, which is a pretty terrific number. And that gives you a really pretty accurate assessment of what the problems are. And now, do you want me to talk about what we got back? Do you have any specific areas you want to address to me, John?
Well, just in a general sense, what were the major findings?
Okay.
What did you learn?
Okay, let me start with the good news.
Thank you.
Okay, I like to do that. When the original task force report was issued, women judges throughout the state were few and far between, which was very unfortunate. The fact that when I was appointed to the appellate division in 1985, in the first department, that's covers Manhattan, the Bronx, probably more women lawyers in that area than anywhere in the country. I was the first and only one in that court for 11 years. That's pretty sad when you think about it. The first report was issued in 1986. Well, and there had, Judge Kay was on the Court of Appeals, but other appellate courts were pretty barren in terms of any women members. And women judges throughout the state, particularly outside of the city, were few and far between. In the city, the family court had quite a few. Well, fast forward to the second report, 30 years later, the number of women judges is astounding. We have had periods where the Court of Appeals, our highest court, has had a majority of women. The court where I was alone for 11 years, today is a strong majority women. The second department has women, and even the third and fourth, which are outside of the city, have multiple women. And there's a woman PJ in the third department. All of this, believe me, 30 years ago, I would not have believed it were possible. And to me, even more important, at the local levels, you have women administrative judges. And in the non-judicial sector, we have court officers, court clerks. Listen, when I came into the system, they were pretty uniformly men. Once in a while, there'd be a woman. Hey, today, many of them are in leadership positions. And I think that has been terrific. And that was reflected in many of the answers that we got, I think. First of all, what is the atmosphere in the court system to women lawyers, women litigants, women witnesses? Well, women lawyers today the data indicates, as far as judges are concerned, judges do not demonstrate bias against women lawyers. And court personnel have improved in that regard markedly. Unfortunately, other lawyers, and I guess that's for the most part men lawyers, do show bias toward women lawyers and to women witnesses and litigants. And that's a very, almost to the same extent that they did 30 years ago. And that's very distressing to us. I must say that. Also, credibility. After all, when you go to court for a case, credibility is critical. Now, the report indicated, from the data, women lawyers and litigants and witnesses are given less credibility by judges in a lesser degree, but lawyers really take advantage in that area. And that's terrible. That's something that we really, because that interferes with a just result. That you take two witnesses, one is a man, expert witness, the other's a woman, and you automatically give her less. Now, I'm not saying that it is a majority, an overwhelming majority, but it is sufficiently concerning that we have to be aware of it and seek to eliminate it. Now, when we talk about, when I said to you, judges were not, I hate to use the word guilty, but judges didn't engage in untoward conduct toward women lawyers, litigants, etc. But the one area that we fault judges on is that if they see it happening by lawyers or by others, they don't necessarily intercede. And they control the courtroom. They have an obligation to intercede, both in the courtroom and frankly, within the profession itself. After all, judges are the leaders of our system of justice, and they have to set the pattern. There also other areas where there have been improvements. For example, in terms of the issuance of orders of protection, where women, and in most cases it is women, are the victims of domestic violence. There has been a big improvement on that in terms of how the police address it and how it's addressed generally. One of the things that's of great concern there is that the courthouse does not have safe spaces for those victims on the first return. And, this goes, of course, to the whole issue of financial stability of our entire system. We're at a terrible crisis now. I don't have to tell you, financially. And while there are, it depends on the courthouses within the city of New York, some of the institutional, domestic violence groups do have some safe spaces. Overall, when a woman comes back on the initial, order of protection date, there are not safe spaces, and that can be very dangerous. And we make a lot of recommendations about posting information in courthouses, one, as to where to report incidents of discrimination or abuse or maltreatment, and that's important. The public has to be aware if something is wrong. There's got to be a way to report it and report it easily. And we've made very specific recommendations. And we're now in the process under the aegis of Judge Richardson Mendelson of trying to implement many of those reservations. An area to me of particular concern is the support provisions upon termination of marriage. Some legislation has been passed over the course of the years that, in my view, and the view of several judges and others, does not properly take into account the length of a marriage and the realities of the ability of a woman who's been out of the workforce for many years to, in fact, be able to obtain appropriate employment. And the statute is not very sensitive to that, nor does the statute, both as to equitable distribution or support, give appropriate emphasis to the value of work that has been traditionally considered women's work. The tort lawyers in New York City, pretty smart guys and women, and they know how to lay out what it costs to do all of the tasks that an ordinary homemaker does or a caretaker does. They can assess an economic value to it. But that's in their tort cases, a limited number of cases. That has not been accepted system-wide, and it's not reflected in support awards or in equitable distribution, or when a woman is injured. If she doesn't get the right lawyer, juries don't look upon that kind of work as appropriately either in terms of its economic value. These are just a few of the issues. Listen, I could sit here for a couple of hours and talk about this report. I don't think that's what you have in mind. But let me just sort of say this. We've come quite a way, not far enough. We still have a way to go. And we are not giving up. We believe in a truly fair and equitable system of justice at every level. And that means women are entitled to that same standard as are their counterparts.
One of the parts of the report that intrigued me is one, you're calling for more human trafficking courts.
Oh,
And, I think it was a dozen years ago or so, New York enacted what is supposed to be maybe the strongest anti-trafficking law in the nation. And it seems, looking at the numbers from the Division of Criminal Justice Services, that may have fired blanks. I mean, in 13 years, we've had a grand total statewide of 127 convictions for sex trafficking, 103 of them in New York City. So, roughly 10 a year. So either we don't have a problem or we're not really addressing it.
Oh, believe me, you have a problem. Listen, I have always said every pimp is a trafficker. Let's be honest. That's what we're talking about. And that's obviously a very complicated area. I sat in criminal court, and I'm going to tell a tale out of school. When I would get a pimp in front of me, I was considered a pretty liberal judge. I didn't throw people in jail unnecessarily. Legal aid used to love to appear before me, let's put it that way. However, when I would get a pimp in front of me, listen, I didn't count 180, I didn't count Saturdays, I didn't count Sundays, Mondays. I would put those guys in. The problem was, they have such control over the poor women that they traffic. You can't get much out of them. But I used to say, let those terrible people know what it's like to be back there, because the prostitutes were incarcerated. And I was always big on having services, for prostitutes to try to get them out of that life wherever possible. It's a terrible problem. And part of the problem, we've had many meetings of our committee where we've had members of DA's staffs, and I got to give many of them credit. They're really, those who do that kind of work are really committed, but they are confronted with the difficulty of getting witnesses. Hey, listen, we have a due process system, and that, in a sense, is one of the prices you pay. You do have to have evidence. And if you can't get evidence, unfortunately, but they try to use many creative ways. Also, we don't have the trafficking courts throughout the state. I was a big proponent of that under our last chief judge, and he started, a couple of them. But again, economics interferes. Do you know what I mean? And it's just like one of the less, exciting parts of the report, you might call it, are the facilities portion. Many years ago, there was a committee started, I think by Judge Kay, on women and children. And it was Ellen Shaw was one of the co-chairs. Now, I knew her from the courtroom. She used to appear before me when I sat in criminal. So she calls me up, do you have any ideas? And I suggested, what's terrible is many of the low-income people have children. Listen, a woman can't afford to hire a babysitter, so she can lose her apartment because she can't answer a call in housing court. Many of them have to visit, want to visit the mates in the criminal court. We got to have waiting rooms or nurseries. I think I called them nurseries at that time. Oh, she says, that's a great idea. She wrote it down. And they, she's now at NYU where I'm a trustee associate. Anyhow, that did take root. And we did start, they were started in many areas. For example, Suffolk County had one of the best. Would you believe that? Really terrific. And we had one in New York County at 111 Center Street. That's the civil court building. And we're doing pretty good on all of these. They were expanding hours, what have you, and they served a wonderful purpose. The family courts still have them, by the way, in every family court, and they're obviously very critical. But the litigants could come in, leave the children at these nurseries or waiting rooms, as you will, and they could go off to the various parts. Then came 2007 with the recession. They had a big article in the Times yesterday about it. And of course, bingo, the hours were reduced. I remember the then chief administrator was someone who was very committed to it, Judge Fow. And I remember meeting with her and with the president of the state women's bar, and she made a commitment when the budget, allows, that will be one of the first things we'll do. Unfortunately, that has not come to pass because of the budgetary restraints. But that's an important issue, and we're trying to find creative ways to perhaps incorporate community involvement. Do you know what I mean? So that those, okay. Then another thing, in my time, the thought that you would want a lactation room, for a new mother, I didn't even think about that. And I had 3 kids during the time I was a law clerk. But, okay, hey, today, a lot of women lawyers and women judges as well, and women court personnel are new mothers. And they are entitled, they want to continue with their careers to work. All they need is a lactation space, because more and more there's natural breastfeeding. And in New York City, there are many, a good number outside of the city, lacking. And the irony is that's also something that a little money could provide. They have what are called pods that would be okay for that. But that's something we're pushing. I want you to know. And another thing that may sound amusing, baby changing tables. Listen, you go into some of these courts and you see a baby being changed on the bench outside of the courtroom. Now, that's not really good for the baby, for the parent, etc. Every bathroom, male and female, should have a baby changing table. And of course, we don't, the court system, I still say we, in my heart, I'm still there, don't own the buildings in which we operate. And so we are sort of subject to the whims and what have you of those who do. And again, money becomes a predominant factor. But that, to me, pretty easy to win. Certainly in new buildings, there's no excuse. But to put in a baby changing table in a bathroom, I think that's manageable.
It sounds like you have a mix of recommendations, some of which I would say are quite easy to achieve, some which require legislative changes, which are a lot harder to achieve. And some that require some financial commitment, which in the middle of a pandemic may be difficult to achieve. But otherwise, I don't think we're talking a whole lot of money. Is that correct?
Well, it depends on who you talk to. Talk to me. Listen, it's not too much, because what you're seeking to correct is so egregious that whatever that amount is, it's critical. Listen, one of my pets is supervised visitation. I was a member of the Moreland Commission before it was disbanded. And I remember we were having a talk and somebody raised supervised visitation. And one of the DAs from upstate said to me, well, the court provides that, don't they? I said, no, unfortunately, they don't. And he looked very shocked, like, yeah, that's something the court should provide, and it should. But, that becomes a big thing of supervised visitation. There are entities you have to pay if there's no appropriate family member available. It's a very complicated thing, but again, there's money. And when you put together all of the little, the money pockets, especially in today's climate, we're going to have to come up with some creative ways. We may have to have cake sales.
That's a great way to put it. Judge Ellerin, you've been promoting equal rights for 75 years, and I don't get any indication you intend to slow down.
I hope not. I'll keep trying.
Thank you so much for your time, Judge.
Okay, good to see you, John.